Mr. Robert Joyce, who is with the Better School Government, he made the comment also that that was not appropriate to have that happen in any setting, that it did change that meeting once that happened. Even though it was an ex-officio member, that he still could not participate in that meeting. So that's basically all I have on that.
Mr. Chairman, if I may make a suggestion, can we allow the sinks to respond?
Well, that's what I'm going to do. We're at just over 6 minutes, so I was going to call on Mr. Sink to provide any information he sees fit, and you've got 3 minutes and 40 seconds.
Mr. Chairman, Mr. Vice Chair, members of the board, here's a semester-long class at the UNC School of Government in 3+ minutes. This was an open meeting of the committee before the chairman stepped into the meeting. That means it had to be noticed, properly noticed, in enough time for the public to have access to attend that meeting. That is the entire spirit of this law when you get into 143-318. So there's no dispute that it was an open meeting at all. It was an open meeting, properly noticed. We went back and factually checked that. Within 5 or 15 seconds, you were able to click onto the website, Mrs. Sink, and access the standing committee meeting notice for the policy committee where it is so that the public can access that. That's why this matters. That is why this matters, is for public notice so that they can access it when the board is doing its business. Now, I want to draw a distinction because at law, we're throwing around 143-318 over and over and over. So here's what's important about that. The majority of the members of a public body, they were present, check, for the purpose of conducting hearings, participating in deliberations, or voting upon or otherwise transacting the public business within the jurisdiction, real or apparent, of the public body. If you don't remember anything else, remember this from what I'm saying. A committee, a board committee of a body politic cannot act on behalf of the full board. That is why no law, in our opinion, was violated. We talked to the School of Government. We talked to Bob Joyce. Bob Joyce told us in our conversation, it was specifically Leah, in her conversation with Bob Joyce, who I've gone to dozens of times over the last 14 years, that half the judges might call it a technical violation, half the judges might not. Board policy, your board policy today, allows the chairman, whether it's you or somebody in the future, Mr. Queen, to participate as an ex officio member of that committee. The tradition of this board has been for ex officio not to mean a voting member, and that's why you, I think I left after 10 minutes into the committee, Leah stayed, participated but did not vote. You talked but you did not vote. So what is participate? Well, we don't have another 5 hours to deliberate that. And I do apologize for that. I wish I could talk for 30, 45 minutes on this because I do think it matters. There was proper notice, standing notice. It was noticed from the dais, and whether it's Mr. Queen or somebody else on this board who's chairman, in our legal opinion, it was not a violation of law or policy. If anything needs to be looked at here, in our opinion, without giving legal advice, but a suggestion that has come from the board and not me, it is looking at this policy and going from there, potentially tweaking the policy.
Mr. Chair, can I just say one thing that...
Real quick, there's 10 seconds.
All right. I would like, if they have these people they've talked to write this down, because if it is a violation of law, we not only had one violated, we got two. That's you and you.
All right, we've reached our 10-minute limit, so debate has ended for this subject. So we'll move on to the next item on the agenda.